On March 6th of this year, Mr. Justin Stottlar, who's seated beside me, a recent elected member of the Perkasie Borough Council, called me to advise that after doing some legal inquiring on his own, he had concluded that he may have participated in a meeting which violated the Pennsylvania Sunshine Act. Because this office had shown itself ready to prosecute elected officials like Barbara Riley, Mr. Stottlar was concerned that he not be subject to prosecution for this unknowing violation. I determined that Mr. Stottlar's concerns appeared to have merit and assigned Larry King, a consultant analyst in my office, to meet with Mr. Stottlar. Mr. Stottlar provided Mr. King with a 3-page memorandum, which included a proposed sale of real estate owned by the Borough of Perkasie, upon which is erected an old power generating plant now used as the electric department headquarters. The prospective buyer of that property, Vacubraze, owns property in the immediate vicinity of the electric department and is a substantial consumer of electricity from the borough. Perkasie Borough at one time operated its own generating facility back in the dim, distant past, but has long since given that up, retaining the electric distribution system by which it now distributes electricity purchased from other producers. I'm told that's common with many boroughs, both in Bucks County and elsewhere. Also discussed in the memorandum, which had been prepared by Borough Manager Daniel Olpere, was the prospect of selling electricity to Vacubraze at a reduced rate. Immediately below the heading on the memorandum, Mr. Olpere wrote the following: confidential. The following information is confidential and is intended to be discussed in executive session at the next council meeting. Because the majority of the subject deals with a potential real estate transaction, it should be deemed confidential and can appropriately be discussed at an executive session. End of quotation. What Mr. Olpere told his council members is not correct. It is not an accurate statement of the law. Nevertheless, an executive session was indeed held on March 5, 2012 by the Borough Council, at which time both the prospective sale of the real estate and the creation of a reduced electric rate for Vacubraze were the principal topic of discussion. This is not allowed by the Sunshine Law. However, the language of the Sunshine Law authorizes the imposition of penalties only upon the elected members of the Borough Council or other governing body, whatever it might be. Moreover, even those elected officials may only be penalized when they participate in a Sunshine Act violation with the intent and purpose by that member of violating the Sunshine Act. Because the members of Borough Council had every right in good faith to rely upon the words of Mr. Olpere, and because their solicitor was privy to the memorandum and present throughout the proceedings without comment, there was no reason for any of the Borough Council members to believe that they were acting contrary to the law, and certainly no reason for us to believe that they had the intent and purpose to violate the law. However, because of the seriousness of the matters involved and the need to prevent such conduct in the future, my staff and I deemed it appropriate that this matter be submitted to the current investigating grand jury so that we could get at the truth of the matter and so that we could have the benefit of the voice of the community, which our grand jurors represent, in determining an appropriate response to this conduct. After hearing testimony and receiving evidence as described in their report, the grand jury determined to issue a report. In that report, they find that the Sunshine Act was clearly violated by the discussion in executive session of a proposed sale of borough property and the discussion of the establishment of a proposed favorable electric rate for a single business in the borough. However, they concurred with our analysis, and I will say specifically, buck stops here, my analysis, that the manager's advice in his memorandum constituted a defense to prosecution of any of the Borough Council members. Accordingly, the grand jury recommended changes to the Sunshine Act itself to prevent a recurrence of situations in which the paid professionals of an elected body can shield elected officials from criminal liability for violating the act by making sure that managers, solicitors, others who would advise on this point have, as the expression goes, skin in the game in the form of their own possible criminal liability. The Sunshine Law is clear. There are, when you're discussing matters of policy, except for the exceptions that are spelled out in the Act, you've got to do it in public. And we know I've been around government one way or another for a long, long time, and I have always believed that Sunshine is the best antiseptic. Evidently we have the Perkasie solicitor here. I don't know whether he wants to offer rebuttal. I'm not inclined to get into a debate today, but at any event, we'll let him in. Pretty simple and straightforward. And in this case, the borough manager attempted to justify his actions, and this is detailed in the report, because they were discussing a real estate transaction. Well, that's not what the Act says. The legislature made a clear distinction for their own purposes, and I can see from a policy standpoint why they would, that if you're selling property that's already owned by the taxpayers, that's not a proper subject for an off-the-record meeting. Notice, it is notable, and I don't know whether Perkasie's just unlucky, but there was quite a stir about exactly this kind of problem in Perkasie in the early 2000s. Although I think it was called Mr. Olpere's attention that he came in the aftermath of that and actually is quoted as commenting in one or two of the news articles from the time. Yes, sir.
Isn't it the, maybe you addressed this before that, but isn't it the solicitor's responsibility to advise the Borough Council on provisions of the Sunshine Law and what can and cannot, what activity, action can and cannot be taken in private session?
Sure. And it's also, especially when you have a borough manager as experienced as Mr. Olpere, you would not think that he would be giving people advice in the memorandum that says, don't worry about it, this is on the up and up. That there is a significant distinction between selling property that already belongs to the taxpayers and debating or planning to buy. He should have known better. Whether he did, I'm not the, what is it, the shadow knows, sees into the hearts of men. I don't know exactly what he knew. I know that I can't prosecute him under the Sunshine Act.
Justin, sitting in that meeting on March 5th, did you realize then that there was something perhaps unkosher going on?
What was going through my head was what could be talked about in executive session under the Sunshine Law. So what I did that evening was I went home and got my Pennsylvania State Association of Boroughs book and got my interpretation that you can only talk about the acquisition of the property, not the sale. I contacted the Pennsylvania State Association of Boroughs the following morning, and they agreed that my interpretation of the law was correct, and at that point in time is when I had called Mr. Heckler.
Do you believe that any of your fellow members of council thought something was not right?
Judging by some comments that were made, I do feel that there were some. There are some others that may not have known. But again, our borough manager has a long list of credentials. He speaks on government. He should be well aware of the law, and so should our borough solicitor.
It would seem pretty plain to me that a proposal to set rates differentially for one, particularly for one industrial customer, is also a matter that you just can't discuss behind closed doors. And
Is this a solicitor?
yes, he is.
May I ask you, were you aware of this provision of the Sunshine Law?
Yes, and Mr. Olpere and I conferred, and our interpretation of the law was not the same as the district attorney's, and I will have to review our actions going forward, it seems.
But Mr. Heckler has indicated that it's a fairly clear-cut provision in the Sunshine Law. Are you saying it's not as clear-cut as you would portray?
Having just walked in a few minutes ago, there's a different interpretation of that provision regarding the lease and purchase distinction, and as from what I understand of the press conference, the DA will be making recommendations to the legislature. Beyond that, I can't comment any further.
Can you just give your name, please?
Nathan Fox.
And how long have you been solicitor for the Perkasie?
Since February.
Of this year?
Correct.
Are you a solicitor for any other municipalities?
Just Perkasie.
Do you work for a law firm?
I do.
Can you tell me about this?
Begley Carlin Mandio.
As an attempt to stick it to certain members of council and perhaps the administration. Do you have any response?
I don't believe that it's that at all. I started this political action committee because of the electric rates. We had a 66% increase over 2 years. Electric rates are at their all-time lows right now. My understanding from my constituents was they put me into office to put a stop to doings such as the violation of the Sunshine Law. As you heard Mr. Heckler say, it has happened in the past. My constituents want the governing body in Perkasie to be completely transparent with them. So I chalk it up as simply me doing my job.